Hey everybody, good morning. This is JD Houvener, managing partner and owner here at Bold Patents Law Firm. You made it to the Bold Today show. Welcome. Bring on those inventors, entrepreneurs, business owners. We're here to answer live questions and have a growing audience here every week. We're here every Wednesday at 9 a.m. In the morning on the West Coast, noon on the East Coast. Today we're talking about cool tool inventions and have nothing better than we've got a client of ours who has been bold and brave enough to come on with me today. His name is Kevin. He's going to be on just in a few minutes. I'm excited to introduce him and his tool that he is now patent pending on. All right. So we got a standard agenda today. We're going to bring on our guests, which I'm excited to do that. I'll also introduce a free offer for a copy of this book you see behind me. And then we'll go to our AVO questions. So if those of you that are tuning in maybe after the fact from AVO, hang tight, those answers will be coming toward the end. I saw there was a ton of trademark questions, so hopefully we'll get to a few of those. So that's the agenda. I just put that up on there. But we'll also post a disclaimer for all those that are watching that may be inventing and excited to hear. I do want to let you know this is not a confidential forum, okay? There's no legal advice being given here. There's no attorney-client relationship forums, all right? This is just a fun live forum for you to answer questions that have been spinning around your head for a while. Maybe you're mulling over an idea, or I want to know what the process is, want to see an inventor in person, what their journey is like. That's what this is all about. So welcome. I'm JD Houvener. I'm the owner here at Bold Patents Law Firm. I'm a patent attorney, and I'm here live. So bring the questions on. We're going to prioritize the live questions. And then also, like I said, I'll be going to those questions in the bank that I have at avo.com. So we have 4 listeners and 4 viewers on already. Thank you for those likes and thumbs up. That's what's going to help us share this message. So if you are liking the fact that I'm a patent attorney, bringing on clients and sharing with the world what we're up to, share this with your friends, share this with uncles, nieces, aunts, moms, dads that may also be inventors, right? Help inspire them to be a part of this whole journey with us. All right. E. Dixon, good to hear from you. You're not a citizen. That's okay. If you have, and I create some patents that help in somewhat the local economy, create new jobs. Could that help me become a citizen? Hey, Dixon, I am not an immigration attorney, but I would hope so. And I have heard of different types of programs for those that are either on their way to immigrate, if you're already here, obviously, but there are certain procedures to follow. Why don't you send me a message, all right? Send me an email. I'll give you my email address with my number here to send a text to, and I can introduce you to an immigration attorney, okay? I will not give a direct opinion on that at this time. All right, so I'm going to bring on our guest. His name is Kevin Yaccarino. He hails out of New Jersey. Kevin, welcome to the program.
Thanks for having me.
Good to see you. I see you out in the field. You're not behind a desk right now.
No.
Awesome. All right. Well, looks like beautiful weather out there.
We're really fortunate. Yeah, the weather's changed a lot in the past week. Nothing but ice, rain, snow. Today, I think we're 55, and man, it's perfect to be outside for this.
Yeah, well, thanks again for coming on and being brave. I commend you on that, and also want to start by congratulating you for being patent pending on your new tool device. So thank you again for coming on. So I want to get right to it. So you've developed a tool, all right? And so a lot of inventors out there have got invention ideas, and a lot of people that go through their work day, their everyday, and they kind of think, gosh, I wish there was a solution to this problem. I kind of want to have you take us back a little bit, right? Walk us through what was the problem you had and what sort of started you on this journey toward, finding a solution.
Well, to be honest, my age, I'm getting older. A lot of the things I used to do, I can't do anymore. Muscles aren't as strong, bones hurting. And my wife and I had recently installed a pool. So for the landscaping process, I was getting river rock in, and I would just get a truck in, and where my pool set out back, I literally had to do bucket loads of river rock, and carrying every single bucket, I don't know, 100, 150 pounds full of rock, just tedious every time to carry these buckets back. And I just knew there had to be an easier way.
Right. Yeah, I'm thinking wheelbarrows, but then you fill a wheelbarrow up, and what are you going to do? You can't move the thing. Yeah, interesting. What did you do? What did you come up with?
All right. So first thing I thought of was it had to be something that not only held the bucket, but it had to be easy enough to where it's not just lifting it, but pouring it. So what I had come up with was a concept that cradles the sides of the bucket, holds the bottom, and it came up with a handle. That way, anybody who ever picks up any kind of 5-gallon bucket, they would know that the only thing you have is the regular handle up top and then a little small 1/4-inch piece of plastic on the bottom that you actually have to grip to pour the bucket. And when you're talking, 100 pounds or more filled inside of a bucket, it makes it really difficult.
Right. So you're actually, could you hold it up a little bit higher? Because we got that big banner there. Perfect. So you actually have an ergonomic handle there. It's going to let you use probably a whole other set of muscle groups, right? Get the biceps going, be able to support the thing with your back instead of just, struggling with maybe the shoulder, one of the weakest joints of the body, right?
Right.
Interesting. Okay. And I've got it pulled up as a PDF, a little bit larger. So I'm going to share my screen really quickly. I had this ready to go, just in case people are watching have a tough time seeing that. So just real briefly here. All right. So maybe you can walk us through kind of the major aspect of this invention. Can you see that, Kevin?
Yeah, definitely.
Okay. So what are we looking at? What are the major features of this tool?
The major feature is basically the design of the handle, because it has to be something where there's a million tools out there for certain jobs. Nothing like this, but it has to be convenient. If it's not able to be used right away, like an extension of your hand, people aren't just going to use it. So I had to come up with an actual design to where it felt natural to the bucket, it cradled the bucket, and the pouring motion was really smooth. Basically, yeah, as plain as it looks, and it's only a one-piece setup, there was a lot of prototypes to where it actually operated really smooth.
Okay, so you're actually using the handle of the bucket,
Correct.
pushing that against this as sort of a cradle,
yes,
sort of a two-point cradle, right?
Yes. So basically, it's the position of the handle and the way the staff is actually shaped allows it to cradle the bucket and just the pouring and lifting motion.
Right. That's pretty cool. I just did a painting project. I'm not sure if that's the right application, but I mean, you could probably get more precise with your, handling of the bucket, right?
That was the whole, other than just demo work, rocks filled in a bucket, the industry I'm in now, a lot of our guys use 5-gallon buckets, and anywhere from hydraulic fluids, 5-gallon paint buckets. So I actually set this out to a few guys I know to use it in the field. I spent a year just having it out there. Guys I trusted, I didn't think they were going to steal my idea, to actually use it pouring 5-gallon paint buckets. Because normally, again, with that 5-gallon paint bucket, you have to hold the little very bottom, and it's a very slow pour. Any kind of liquid that goes in a 5-gallon bucket. So I wanted it to go out there and definitely make sure it was not just one purpose for a demo bucket.
Absolutely. Well, I think you've got that shape down. I mean, I think, you're likely are still, even though you're patent pending, you tell me, I mean, you're probably still refining that design, maybe even exploring different material types, end market ready type of position. Walk us through what's next for you. What are you working on?
With this patent?
Yeah.
Since it is my first trial run, coming up with an idea and actually going through with it, I just wanted to see what the process would be like and how easy it was going to be. So I'm not planning on actually making this product and distributing it or licensing it. The whole process and the thought process was see if I can get a quick turnaround on the patent itself, to reach out to large tool companies that would buy the product off, basically just buy the patent outright, just to see what it's like to do it. My wife, she's a full-time teacher, and the career I'm in, I don't have time to actually start a whole nother business venture. So I thought it would be easy for me just to try to sell it outright.
There you go. Well, you're not alone. I mean, there's a lot of inventors out there that have got day jobs. They've got other things they're working on. And you're a great example of someone who's taken action, who's doing this kind of on the side, right? You don't have to dedicate full on to moving forward with the product. There's certainly a path to commercialization. Kevin, yeah, so a couple questions for you. One came in from Jennifer. She's asking, well, what keeps it from sliding off of the tool? Looked like it kind of might be able to slide off, she's thinking.
No, you could probably, let me try to get as little bit close as possible. I don't know how this computer screen works. There's a lip right here. Every bucket, thank goodness, every bucket ever designed has a 1/4-inch lip on the bottom. Every plastic that I've ever seen in the industry. So I had to design it where the weight and the bucket curve would sit in there and literally just lock itself in. And the shape of the part of the handle here helps it lock that part of the bucket in. I went through a lot of different trial and errors where it would fall off. And then I came up with the final concept where it's locked in, it's not going to fall off.
Yeah, just enough of a lip. So it's actually sitting inside of the bucket.
Yeah, it actually,
right?
The bucket cradles the outside of this bottom part to where it'll lock it in. Cool. So, I mean, but the thing was, it had to be convenient to where you can get it on real quick, and as soon as you lift it, it locks.
Okay, good deal. All right. She says fantastic. So, yeah, good work on that. Flavio wants to see a video. So that's an action item for you. Maybe put a little video together and work on that. But here we are, right? This is a video, certainly.
Right.
I don't know if you're going to do a demo or not, but maybe we'll put you backstage and have you prepare a demo for after.
Well, I have everything set up. I came.
You've got it? Let's do it. Let's do a couple of you. Let's see it.
All right. Well, I don't know if you can see me over here. I have my 5-gallon buckets. Normally, what you have is your handle. They are filled all the way to the top with water. Didn't want to go overweight. And usually, normally, you would have to grab it by your fingers on that very little thing that everyone knows about. And it's a pouring action. But as you get heavier with materials, the bucket's going to be a lot harder to lift. My age right now, my back hurts. It's a little sore. So it's basically just pouring, and if it has to be consistent. So what I wanted to do was to make it to where you see a lot of mess water coming out. It had to be convenient and fast. Basically, it locks on the bottom. That's it. And now it's just an easy pouring motion where all the weight isn't taken off your fingers. You're using your whole arm and chest muscles, not just your forearm and your fingers. And it's just a really slow, I mean, I can pour it literally with one finger and it's locked on to the bucket. The weight actually holds it on there. Quick story, as quick as I can get, is when I was trying this out and finalized it, my daughter was 9 years old at the time, and I had filled it with a bunch of rocks. And I had her try pouring the bucket out at first, and she had trouble doing it. She's like, oh, it's too heavy, her fingers are small. So I hope this, I don't have a name for it, never came up with a name, sadly enough. And I made her do it, and I actually did a little video, and she looked at me dead in the face, and she's like, oh my goodness, Dad, it actually works. And that was the moment there I said, I knew I had it. If my 9-year-old daughter can function this thing with a half a bucket full of rocks, anybody can use it.
Cool. Kevin, I can see you on Shark Tank right now, my friend. I think you're on your way. I know you're not looking to raise money or anything right now, but no, that'd be fun. And great demonstration. Don Harris says, great job, Kevin. So let's put you backstage. I hate to, I'd love to hear more, but thank you so much. We'll have you on in just about 5-10 minutes. Hang on.
Yeah, no problem. Thank you.
All right. Well, excellent. Anyway, a lot of people waiting to get those questions from Avo answered. So let me jump to those right now. Thanks for all your guys' question and encouragement for Kevin. That was great to see. Let me share my screen with you as I look through these questions. I saw one from patents, one from patent litigation, and 16 questions on trademark. People are really getting their brands going. Let's take a look at our patent application. I do tend to favor patents, as you can tell. The question is coming out of Gresham, Oregon. Do greeting cards with moving parts need a patent? Okay, that's kind of cool. I want to make and sell non-electronic greeting cards with movable paper parts, like pull tabs, something happening. I'm picturing sort of like a pop-up, right? Do I need a utility or a design patent to protect myself? Is it considered a machine? This is really cool. I would say, your question was, do you need a patent? Probably not. Would it be helpful? Maybe. Okay. So with cards and creations like this, my mind almost immediately goes toward art, right? What you're doing is creating artwork, okay, first and foremost. And so I certainly would think, a sculpture, a design, right, in terms of what the color and the ornamentation looks like. My mind goes to, copyright, right? Protecting the artwork under copyright. So that would be the number one thing to look at to protect the actual end creation that you came up with for each design. Now, if you have a sort of a common denominator in terms of these cards that you make, is there something consistent about the way that they work or with the way that they look, that every card is going to have the same elements, right? It might have other frills and they might change, but if you have some core common denominators, right, that are not going to change with the functionality or with the design, those are things you should consider patent protection on. All right, but a one-off, one-time design or an artwork, that's really more the domain of copyright. Okay, so let's talk each in turn. So functionality, utility patents protect what things do, right? What they actually look like, how things move, what the interactions are, what they're made of. They protect things like the composition of elements, assembling of parts, and of course the actual utility benefit. So you'd have to do some search, right, on your own, perhaps at first, and then hiring a patent attorney or law firm to do a patentability analysis to see, hey, is this new? Is this the first time that pull tabs are combined with a movable, foldable card? Okay, I don't know exactly how the tab is interacting, how it integrates with the different parts, the different paper. That could be the novel. It could be the first time that someone has that type of a mechanism, whether it be paper, metal, whatever the material is, to generate a specific utility or benefit, like opening up a flap. Okay, that would be patentable if we could get through that search and analysis phase. So switching to design patents quickly, if what you've created has certain design elements, right? Tabs that are located in a very unique and aesthetic position on the card, or if it just looks nice, like the organization, the way they're positioned on the card, that would actually lend itself more toward a design patent. And you could protect the way that it looks purely based on ornamentation. So I know there's a long-winded answer. Hopefully it got you thinking. And so please do follow up with us. I gave my email and text number below. Certainly visit our website at boldip.com to look at scheduling a free screening session to see if patenting is right for you at this time. So thanks for your question there. Let me jump back and see if we had any live questions trickle in. Oh, good deal. Yeah, E. Dixon liked your product too, Kevin. Good stuff. All right, let me go back to our patents. We had a patent infringement question come in as well. This one's out of Washington, D.C. I'm looking for a contingency fee attorney to appeal a patent case to the U.S. Supreme Court. My goodness. They lost their motion to dismiss based on a 35 U.S.C. 101 at district court. Not allowed to amend the complaint, not allowed to oral argument. Lost on appeal to the federal circuit, not allowed oral argument there either. Multiple patents granted by Patent Office since Alice were decided. Due process and Seventh Amendment arguments at least. Okay, so this individual said their case was dismissed. All right, meaning I think at the federal circuit, which is just below the Supreme Court, confirmed the district court's decision to dismiss, or basically to invalidate a patent. All right, and this is a very controversial thing, but it is the current state where you can get a patent granted. Right, the examiner reviews it, they say it's good to go, they allow it, and it gets granted. Right, gets issued. You have a patent rights granted, and later, subsequent to that, a federal court can say, no, patent laws have changed, or we're going to reanalyze any subject matter that the examiner may have looked at, or potentially look at new evidence that's now being brought forward to sort of reanalyze and relook at it, to examine it again, to see whether it meets all the criteria of the law as it is at the time it's being argued. All right. So in this case, Patent law likely changed. There was a huge Supreme Court decision in 2014 that sort of changed the way that software and computer methods, computer business methods, are being perceived, and are now a lot of them drawn toward what's called abstract subject matter. And so the issue there is patents that were granted in early 2000s and even early 2010, 2011, 2013 were granted. But now, if you go try to enforce those patent rights, they may fall victim to being dismissed and or invalidated by the district courts. So this is going to be very subject matter specific. Some patents will still have a good standing and the ability to argue. Some just don't have any legs to stand on. So I'd have to take a look at your specific case. It would be a in-depth review to be able to provide you an opinion on validity and whether you have a real case against whoever you're up against. All right. Well, thank you for your question. Hope that was helpful for you. Just about 10 minutes left. I think I have time for one trademark question. Let me jump into that. All right. This one came in just today. A lot of questions. This one's out of Bellingham, Washington, actually, just north of where I'm at in Lake Stevens. If my business owns the trademark for Aqua Dream, can I also use Aqua Space Dream or Aqua Dream with capitals, or even Aqua Dream or Aqua Dream with one capital, one non-capital? All right. Trying to establish a standing usage, just starting as a webmaster for an existing company. They own the trademark for, we believe, Aqua Dream. Certainly. With word marks, if they actually have a registered word mark, if it's one word, in almost every case, okay, almost every case, you're going to be able to have protection over similar, right, substantially similar word marks in the same classification. So if you, let's do hypothetical here. If Aqua Dream, and let's just pull it up. I think we have some time. And here's how I would copy Aqua Dream. Let's head over to our trademark electronic search system. Let's see if we actually can pull this up live. Aqua Dreams, plural, okay, is the only one that came up. So this thing here is not live. It is dead. They get a little bit morbid with their classifications here. It was filed in 1998 by Aqua Dreams Limited, a California company, but it was canceled in 2007, likely because they just failed to pay the fees to keep it maintained. That you have to continually maintain a mark, and while you do that, provide evidence that you're still using the mark in commerce. So for who knows, any number of reasons, maybe the market tanked or whatever happened, there wasn't a reason to keep the mark going. Usually it's because a company goes out of business. Currently, there are no rights, no current registration for Aqua Dreams, at least what I could find in my quick search, okay? And so that's a short answer to say there are no rights currently for Aqua Dream. And if you're the same company, you'll need to try to revive the trademark rights. If you're not Aqua Dreams Ltd, then you'll need to apply for a new registration, and also make sure that there is no other confusingly similar mark that's in common industry. So bottom line, you're going to need to get with a trademark patent attorney to make sure you're covered, do a search, and then do a new application and or a revival to make sure we get you properly protected. Thank you for your question. All right, we're just about 5 minutes away. I want to make sure we have enough time to bring someone else back. So E. Dixon said, so it's 15 years of protection for a design patent. That's correct. And 20 for utility. So in those years, will I be receiving royalties? Of course, it will depend on how or what deal you make. True, absolutely. So as the patent owner, in terms of getting a licensing deal, you are still responsible for maintaining the patent. And much like I just mentioned with trademarks, you have to pay and maintain the rights to be able to have a valid license, right? Someone who is licensing your patent relies on the fact that that IP actually exists, of course. And certainly, a license holder, whether they be exclusive or non-exclusive, will be we'll be very interested to make sure you maintain that. Now, the 20 years for utility is based on the filing date. So in almost every case, it takes a year, sometimes 2 years to get the patent granted. So the real duration is more like 18-ish years after grant. That's how long you have to get those royalties. For design patents, it's 15 years after you get the grant. So it's 15 years right at the point where you get those rights. So it's a little bit shorter. And Flavio, I'm going to follow up with you specifically on the swirl fork. Maybe you can do your own searching there. I'll give you guys the URL to kind of do your own search. If you go to tmsearch.uspto.gov, you can do your own search. Okay, have a look around. If you get stuck or need extra help, shoot me an email, Flavio, or anyone else that has questions on trademarks. All right, so let me bring Kevin back on. Kevin, all right, you still there?
Yeah, I'm still here.
Okay, perfect. Well, just a few minutes left. I didn't see any specific questions for you at this time, but I wanted to give you opportunity to kind of walk people through that may be thinking about this, right? They're like, I'm not sure if I want to get into the whole patent world, but I've got an invention. Maybe you could give us a quick 1 minute. What was going through your mind? Maybe what concerns or hesitations did you have before giving us a call?
I mean, there were so many, but I mean, after the first phone call we had, pretty much all my questions were answered. Not necessarily my wife's, but mine were. It was just smooth. There was, I mean, really, there was no concerns after the first meeting with your company.
Cool.
I mean, to me, it was the easiest thing ever. Like, I had a product. I had already put the product out there to test it, and the paperwork portion, all the legalities of it, your company took care of. I mean, it was literally the easiest thing I've done. I definitely had nightmares thinking it was going to be like a disaster, but it wasn't.
Good. Well, that's so good to hear. Thank you for sharing that. I appreciate it. For all of you out there that are, worried about that, and you may want to speak with you, Kevin. Are you open to taking an email, maybe a call from an inventor? Yeah. All right. Well, good deal. Well, if you're okay with that, we'll post your email up here to give that information out to encourage other inventors. That's what this is all about, right? People that have that hesitation, not sure they want to take that step. So you've done that. Congrats to kind of being patent pending. We do have one question. Last one looks like coming in from Flavio. Did you make the prototype on your own, or did you find a manufacturer for the bucket tool?
No, I made it myself. I'm kind of an artist, like an off-trade artist, so I do a lot of metal sculpting. So I was able to fabricate the whole thing myself.
Cool. There you go. Well, good work. I appreciate you coming on again, and we'll hopefully see you back here when you got a deal, right? You've got your patent in hand, and you're ready to move forward. So take care, Kevin.
Thank you
so much. Have a good day.
For having me.
Bye-bye, everybody.